This is the Baker Act Guardian Advocate Training, Module 2.
What you been working on there?
Huh?
What you been working on there?
Figuring out the scrolls. See, I'll tell you what the colors mean. Okay. Emerald green is for my cousin's ship, Earthling ship, which we call Debbie, or Deborah Jean Cyclovitas, and she's professing to be Dr. Cyclovitas. Meanwhile, she's a witch doctor. And that other doctor, Cyclovitas, is really Mrs. Esther's first name, Rosemary.
Mrs. Cyclovitas, you told me...
I'm not Mrs. Cyclovitas, I'm Mrs. Abba, A-B-B-A.
Mrs. Abba, excuse me. You were telling me about yourself earlier. You were telling me that you have a medical background.
Yes, I do.
Can you describe the background in medicine that you have?
Well, I'm a neuropsychiatrist.
You're a neuropsychiatrist. But that's not the only occupation that you have. You've done several other things, is that true?
Yes.
You want to go into that?
I'm self-employed at Laptop Computer Systems. I'm the creator of Laptop Computer Systems and most other computer systems, too.
Okay. What can we do for you today?
In this module, I'll present information on the training criteria for becoming a guardian advocate, as well as detailing the duties of the responsibilities of that role. I'll review the eligibility standards and discuss effective decision-making and required reports and record keeping. Confidentiality will be defined in terms of clinical records. A guardian advocate is the informed decision maker for an individual found by the court to be incompetent to consent to their own mental health treatment. The court may authorize a guardian advocate to make general and specific medical decisions for that individual. At the involuntary placement hearing, the Florida legislature requires that the court appoint a guardian advocate for an incompetent individual who does not have a guardian. This Baker Act/Guardian Advocate training provides a framework for appointed guardian advocates to build upon while learning from direct experience. This training is approved by DCF as meeting the standards for the 4-hour Guardian Advocate training. It is also sanctioned as a CE Broker approved course. Before actually exercising their authority, the guardian advocate is to complete a training approved by the court. This training shall be not less than 4 hours and must include, at a minimum, the duties of the guardian advocate, the ethics of medical decision making, information about the patient rights, diagnosis of mental illness, and psychotropic medications. This training course takes the place of the training that's required for guardians that are appointed under Chapter 744 of the Florida statutes. You'll find information regarding these required topics in the course modules as listed here. Each is also identified under the objectives for that particular module. Once you've successfully finished this course, you will have earned your certificate of completion. Print a copy of that certificate for your file and also provide a copy of the certificate when you visit your ward in either the hospital or crisis unit, receiving or treatment facility. As a reminder, this certificate is specific to those guardian advocates serving individuals in a mental health setting. Once the individual is released, this guardian advocate certification is ended. Continuation of the role of guardian advocate then reverts to the qualifications established under Florida Statute 744. A guardian advocate may be appointed for an individual who is incompetent to consent to his or her own mental health treatment at the time of the involuntary placement hearing. They may also be appointed to consent to medical treatment at the involuntary placement hearing. A guardian advocate may be given additional specific authority at a separate special court hearing to consent to any of the following: an abortion, sterilization, electroconvulsive treatment, psychosurgery, or experimental treatments that have not been approved by a federally approved institutional review board.
Paul believes he is a failure at his job and with his family. Lately, nothing has brought him joy. He cannot sleep and has lost 10 pounds in the last 2 weeks. He is suicidal and thinks about death all of the time. After he threatened to overdose, his wife, Susie, called law enforcement. The responding officer initiated a Baker Act and transported Paul to the nearest Baker Act receiving facility. Following the 72-hour examination period, the circuit court determined Paul met criteria for involuntary placement. He was transferred to a treatment facility for up to 6 months. The circuit court appointed Susie as his guardian advocate.
The scenario just described is increasingly common in terms of situations requiring the services of a guardian advocate. This chart reflects the number of involuntary examinations initiated and reported at intake to the Agency for Healthcare Administration. The need for qualified adults to become guardian advocates continues to grow, as well as the number of adults that are adjudicated incompetent. The statewide Public Guardian Office provides excellent resources for information and additional training by county regarding guardianship. In 2014, the statewide Public Guardian Office, through their various guardianship programs, served about 2,671 incapacitated persons. Approximately 6.1% were provided guardian advocate services. Wards or incapacitated persons range in age from 19 to 106 years old. The common health conditions of these incapacitated persons, aside from developmental disability conditions, are neurological conditions and psychiatric conditions. Neurological conditions are defined as including, but not limited to, Alzheimer's disease, other dementias, and epilepsy. Psychiatric conditions are defined as including, but not limited to, obsessive compulsive disorders, schizophrenia, depression, and anxiety. The most frequent assistance needed is physical assistance, such as bathing or dressing. Most incapacitated persons are unable to perform instrumental activities of daily living as well, and these would include money management, taking their medication, transportation, housekeeping. Most, approximately 73%, are cognitively disoriented in at least one sphere, be it person, time, or place. Generally, there are 3 types of guardians in Florida. If a court determines a person needs a guardian and that person has family or friends who can serve, then the court may appoint that family member or friend. These people are considered non-professional guardians. If the incapacitated person does not have a loved one who can and will serve, but they have assets, the court may appoint a professional guardian to be paid from the person's assets. If the incapacitated person does not have family or friends and is of limited financial means, then the court may appoint a public guardian if one is available. Any 3 of these types of guardians may qualify as guardian advocates. For our course, the guardian advocate would be the individual appointed for a person who is incompetent to consent to their own mental health treatment at the time of an involuntary placement hearing. For more information on the various types of guardianships, contact the statewide Public Guardianship Office. The responsibilities of a guardian advocate are to protect the informed consent rights of the individual that's held for examination or treatment, to seek information needed to make informed decisions, and to make decisions concerning treatment, that the person would have made if competent to make them on their own. This is known as substitute judgment. This means that a guardian advocate can provide consent for treatment, refuse consent, or revoke previously given consent. In addition to the informed consent, guardian advocates protect mental health legal rights. The process of becoming a guardian advocate of a person does not require the hiring of an attorney. During the guardian advocacy proceedings, the court will appoint an attorney for the person to ensure that their best interest is protected. If there is property involved other than Social Security benefits or other government payee programs, the person seeking to become a guardian advocate of the person and the property must hire an attorney. These property rights include, but are not limited to, a pending lawsuit, estate matter, or other income or property right coming to that person. The court can expand the description of property rights by petition and order. Any resident of the state of Florida who is 18 years of age or older and of sound mind can qualify to be a guardian advocate. In addition, a non-resident may serve if they are related to the ward by blood, adoption, or law, according to Florida Statute 744.309, paren 2. The court may appoint any person that it considers fit, proper, and qualified to act as a guardian, whether or not they're related to the ward. However, the court does give preference to a person who is related by blood or marriage to the incapacitated individual, an individual who has relevant educational, professional, or business experience, someone who has the capacity to manage the finances involved, or has the ability to meet the requirements of the law and the unique needs of that individual. The court would also consider the wishes expressed by the individual to whom the guardian is appointed. A competent adult can choose their healthcare surrogate at any time. The healthcare surrogate provides informed decision-making based on an understanding of the individual's preferences for care. This may include applying for benefits or arranging for transfer from one facility to another. The authority of the surrogate only occurs when the individual becomes incapacitated or when the individual is unable to speak for themselves. The healthcare surrogate designation can be done at the same time as a living will. Do note that circumstances may arise when a judge makes a selection based on other criteria.
As a healthcare surrogate, the court appointed you as a guardian advocate for Roger. Your appointment authorizes you to consent to medical and psychiatric treatment. Roger is currently residing in a mental health facility on an involuntary placement order. He is also undergoing treatment for leukemia. The physician has ordered a blood transfusion for tomorrow to boost Roger's red blood cells and increase his energy levels while undergoing treatment. The guardian advocate approved of this treatment decision.
In selecting a guardian advocate, the court must give preference to a healthcare surrogate. If a healthcare surrogate has not been designated, then the judge makes the selection in the following order: a person's spouse, an adult child, a parent, the adult next of kin, an adult friend, an adult trained and willing to serve as a guardian advocate.
Roger's only living next of kin, his aunt, arrived at the facility to visit. She insists that Roger would never consent to a blood transfusion. As next of kin, can she override the guardian advocate's approval of the transfusion? No. Should the guardian advocate consider the aunt's concerns and possibly revoke authorization for his treatment? It depends. As guardian advocate, you must decide what Roger would choose if competent to make his treatment decisions. You must also decide who you wish to speak with before making your decisions. Therefore, it is a judgment decision whether or not to speak with Roger's aunt and accept her input of kin.
Here's a step-by-step process of becoming a guardian advocate. Note that this is a general process. Each county may have additional requirements specific to that court. First, complete the necessary paperwork. Possible forms may include the application for appointment as guardian advocate, application for appointment as standby guardian advocate, petition for the appointment, an oath of guardian advocate, designation and acceptance, guardian education and background check requirements. Sample forms are provided in the resource section of this course. Second, file all paperwork with the clerk of the court's office. The person filing the paperwork is called the petitioner, and the petitioner should attach a copy of the medical records of the person that is designated incompetent. Attach those papers to the petition for appointment of guardian advocate. The petitioner must pay the required filing fee, if any. Courts generally request submission of the original in 3 copies and 2 stamped envelopes and sufficient postage to mail copies of all pleadings. Third, give notice of filing the petition for appointment of guardian advocate. You must serve notice to parties that the petition was filed and the date and the time of the hearing. And fourth, the hearing. Bring your proposed orders filled out completely and typed. An individual who is requesting appointment as a guardian advocate must meet the following qualifications. First, they must agree to the appointment after being informed of duties and responsibilities, and they must meet the qualifications of a guardian as specified in Chapter 744 of the Florida Statutes, in which the proposed guardian must be a competent adult who has not been convicted of a felony, been found to be unsuitable or incapable due to incapacity or illness of discharging these duties, been judicially found to have committed abuse, abandonment, or neglect, been convicted of or entered a plea of no contest to any offense prohibited under Florida Statute 435.03, nor have they provided credit service to the individual being held for examination or treatment. In addition, they are not to provide substantial services to the individual that's being held for examination or treatment in a professional or a business capacity, nor been employed in any capacity that provides services to that individual who's being held for examination or treatment, unless the court determines that the conflict of interest is insubstantial. I'll detail these last 2 items on the next slide. The Baker Act prohibits the following people from serving as guardian advocates: a professional that initiates a Baker Act, such as a physician or clinical psychologist, psychiatric nurse, clinical social worker, a licensed mental health counselor, or a marriage and family therapist. It also excludes an employee of the facility providing direct services to the individual being held for examination or treatment, or an employee of the Department of Children and Families, or a member of the local advocacy council. The court may require a non-professional guardian to submit at their own expense a background investigation, which may include a criminal and a credit history check. If the court determines that a criminal and credit investigation is required, then the results of the investigation will be considered when the court appoints the guardian. For professional and public guardians, the court shall require that they, along with all employees who have a fiduciary responsibility to the ward, to submit a complete background investigation. Immediately after being appointed as the guardian advocate for a person or ward, you will want to do the following. First, obtain a copy of the court order of your appointment as the guardian advocate from the clerk of the court or facility and review it closely to determine the authority and scope of your decision making for that person, such as whether you can consent to medical treatment as well as to mental health treatment. Complete the required 4-hour guardian advocate training or other trainings as required by the court. Visit the person in the facility. Speak with the person's doctor about the person's condition and proposed treatment. The Baker Act requires that the discussion be a face-to-face one if possible, and if not, by telephone. The doctor cannot have a staff member do this in his place. Request the facility to provide a copy of its complaint and grievance procedures. These should be posted within view of the ward. Obtain the names and contact information of the unit director and the hospital or facility administrator for future use. Review the person's proposed treatment plan. It's suggested that you get a notebook in which you can keep a running record. Include the day's date and any key events, the names of staff spoken with, key information gathered, observations made, telephone numbers, or other useful information, and keep a copy of all papers that you sign. You must keep this information confidential. Make copies of any written concerns, objections, or complaints that you may want to submit to the unit director or facility administrator while you're still in the facility, and be available in person or by telephone to facility staff in case a change of medication is necessary or to consider treatment in an emergency. When faced with a serious physical illness, surgery, or other critical medical procedure, a person may need to make difficult decisions. Unfamiliar and stressful situations may seem overwhelming. A guardian advocate should obtain as much medical information as possible before making treatment decisions for the individual being held for examination or treatment. Such information would include the benefits and the risks of the procedures, alternative treatments, and the probable outcome of these options. A court-appointed guardian advocate acts as the substitute decision maker for the individual that's held in a mental health facility. The guardian advocate gives or denies informed consent for treatment when the individual is incapable of making such decisions for themselves. Ideally, the guardian advocate should base treatment decisions on the known preferences of that ward being held. If those preferences are not known, the guardian advocate must make decisions based on what they think the is in the individual's best interest. Making decisions concerning treatment that the person would have made if competent to make his or her own decisions. This is known as substitute judgment. As a guardian advocate, you should honor the individual's values and priorities. You should only authorize treatment that you believe the individual would choose if he or she was competent. This treatment decision might not be the same that you would make for yourself. The guardian advocate puts aside any personal beliefs to ensure the rights, values, and treatment preferences of the individual are preserved. The guardian advocate provides that substitute judgment for the psychiatric treatment and/or medical decisions as authorized by the court. They are to retain these responsibilities until the court restores competence to the individual or the court order expires.
Joanne is experiencing major depression after the birth of her first child. She is on an involuntary placement at a mental health facility. As her husband, you are appointed her guardian advocate over medical and psychiatric treatment. The doctor has prescribed antidepressant medication. However, after 3 months and another medication trial, there is no improvement in her condition.
The guardian advocate should review the medical progress of the individual that's being held for examination or treatment on a regular basis. If the current treatment is not helping or is causing unacceptable side effects, then the guardian advocate should contact the doctor and/or medical staff to discuss the situation. If circumstances warrant, then the guardian advocate may need to consider alternative treatments. In situations when the prescribed treatment is unacceptable and medical staff will not make the necessary changes, the guardian advocate may need to request a different physician. Remember, it's the guardian advocate who seeks treatment information and makes decisions about medical care when the individual being held for examination cannot do so for themselves. Here's a sample of a treatment plan. The facility plan for your ward or individual may not look exactly like this one, but the information in the plan should have the basic components of measurable goals and objectives which serve as markers of progress toward the individual's recovery and discharge, the facility staff who will provide the treatment services, medication information, and discharge planning information. Prior to providing consent, review the clinical assessment and the proposed treatment plan. Speak to the attending psychiatrist about the individual's condition and treatment, and speak to the individual being held in the mental health facility to discuss the proposed treatment plan. In order to ensure that the guardian is acting in accordance with the law, Florida statutes require guardians to submit reports to the court. These reports help the court to supervise the affairs of the ward and to monitor the action of the guardian. A failure on the part of the guardian to comply with any requirements may result in the guardian having to appear before the court to explain his or her failure to properly fulfill their duties. This may result in sanctions against the guardian, including removal as guardian or any other action that the court may deem appropriate. The duties and responsibilities included in this training may not include all of the duties and responsibilities required by your local court, so it's important to check with your attorney and/or the court to determine what, if any, additional duties your local court may require. Guardians are required to file certain reports to the court that has jurisdiction over the guardianship. A guardian advocate must file an initial report within 60 days of appointment. The initial report must include a statement of medical, mental, or personal care services of the ward and a statement of the place and kind of residential setting best suited for the needs of the ward. In addition, the initial report, Form G, includes all physical and mental examinations necessary to determine the ward's medical and mental health treatment needs. In addition, the guardian advocate must file a report each year. The annual report, Form H, must be filed within 90 days from the anniversary date of the appointment as guardian advocate. The annual report must include information concerning the residents of the ward, the medical and mental health conditions, treatment and rehabilitation needs of the ward, and the social conditions of the ward. As the guardian of the property, the guardian advocate is required to submit to the court an initial inventory within 60 days after the court issues the letters of guardianship. The initial inventory must include a list of all the known assets and property belonging to the ward, the location of the assets, and a list of any sources of income, such as Social Security, pension, rental income, etc. The initial inventory becomes the basis for the annual accounting. As guardian of the property, the guardian advocate is required to file an annual accounting. Each year, the annual accounting must include a complete and accurate account of any distributions of the ward's property made during the previous year. It's also to include a year-end statement of all the ward's accounts from each financial institution where assets are being held. The guardian is required to preserve all receipts and proof of payment for a period of 3 years after being discharged as the guardian. In a guardianship of the property where all the assets are maintained in a designated depository and the only transactions that occur in the account are interest accrual deposits pursuant to a settlement or financial institution service charges, the guardian of the property may file a simplified accounting. The simplified accounting must also include a year-end statement from the financial institution. The clerk of the court is required by Florida statutes to review most annual reports. Once the reports are audited by the clerk of the court, they're forwarded to the court for review and approval. A clinical record is a written or electronic record of clinical examinations and treatments. It includes dates of medical care, names of physicians and other involved individuals, and medications dispensed. The record documents and evaluates the progress of the person undergoing care. This record is essential and should any legal issues arise. Florida Statutes 394.455 define clinical records as meaning all parts of the record that are required to be maintained and includes all medical records, progress notes, charts, admission and discharge data, and all other information recorded by a facility which pertains to the patient's hospitalization or treatment. The facility cannot block the guardian advocate from viewing electronic records. The law states that the guardian advocate must have access to clinical records, and this includes electronically stored information. For example, the facility could allow the guardian advocate to view the information via a secure computer or to print the information out. A clinical record is confidential and exempt from the provisions of Florida Statute 119.07 unless waived by express and informed consent by the patient or the patient's guardian or guardian advocate, or if the patient is deceased by the patient's personal representative or the family member who stands next in line of intestate succession. The confidential status of the clinical record shall not be lost by either authorized or unauthorized disclosure to any person, organization, or agency. The Baker Act assures the guardian advocate access to the clinical records of the individual held in a mental health facility. It authorizes the guardian advocate to release clinical information and records to appropriate individuals to ensure proper physical or mental care. Authorization to release confidential information should be made cautiously, balancing the individual's right to privacy against the needs for the information.
Susie was granted the authority to approve both medical and physical psychiatric treatment for Paul. He has hypertension and has a prescription for an ACE inhibitor to treat his blood pressure. Susie requested to review Paul's clinical records to verify that he is receiving the ACE inhibitor as prescribed by his primary care physician and to review his treatment plan. The facility staff refused access, citing patient confidentiality. Can the facility legally refuse the guardian advocate's access to clinical records? The Baker Act 394.46152 FS assures the guardian advocate access to the individual's clinical records. It also authorizes the guardian advocate to release information and clinical records to appropriate individuals to ensure the continuity of the person's mental or physical care. After being refused access to the clinical records, Susie quoted Baker Act statute to the facility staff.
Information from the clinical record may be released in the following circumstances: when it's needed by the attorney representing the individual in a mental health facility, or if the court determines and orders the release of records. If the individual declares an intention to harm another person, the facility administrator may release information to provide warning to the threatened person. When necessary for clinical treatment or aftercare planning for the individual, program evaluation, or compilation of treatment data, records may be released to a qualified researcher, aftercare treatment provider, or Department of Children and Families employee. For purposes of monitoring facility activity, investigating facility complaints, or Medicaid fraud, records may be released to the Agency for Healthcare Administration, DCF, or the Florida Advocacy Council.
Susie's mother-in-law is concerned about her son's hospitalization and wants access to his clinical records. However, Susie does not believe that Paul would want his mother to view certain details within the records. Is Susie required to provide Paul's mother with access to all information in the records? No. Susie may authorize the release of information from the clinical records to appropriate persons only to ensure the continuity of care. The Baker Act does not prevent the parent or next of kin from requesting a summary of the individual's treatment plan and current physical and mental condition.
The parent or next of kin of an individual that's held in a mental health facility or program may request a summary of the person's treatment plan and current physical and mental condition. Release of this information must be in accordance with the code of ethics of the profession involved. Persons have a legal right to access their clinical records unless a physician determines that this would be harmful to that person. If a facility restricts the right to review clinical records, written notice of and reason for the restriction must be given to the person and the guardian advocate. A copy must be placed in the clinical record. A records restriction expires after 7 days, but it can be renewed after review for additional 7-day periods. Confidentiality of personal health information is also protected by the Federal Health Insurance Portability and Accountability Act, or HIPAA. If a conflict occurs between HIPAA law and the Baker Act, the law providing the most privacy protection prevails. This concludes the coursework for Module 2. Are you ready to take the knowledge review? Do you know the training criteria to become a guardian advocate? Can you describe the duties that are inherent to this role? What are the eligibility requirements, and who is a healthcare surrogate? Do you know the basics when it comes to effective decision making? What does substitute judgment mean? Can you identify the reports and record-keeping expectations of a guardian advocate? And do you understand what confidentiality is? If so, then you're ready to proceed on to the knowledge review. If you are unable to answer these questions, then you may want to go back and review this module again before you take that knowledge review. To complete the knowledge review, go back to the M2 tab and click open the Module 2 Knowledge Review. After you've completed the knowledge review, you may decide that you need additional study of this information. If so, return to the beginning of the module. If you correctly answer 16 out of the 20 questions on the knowledge review, you may go on to the Module 3, M3 tab.